Be seated and come to order. My name is Dan Clodfelder, and I am the presiding commissioner this afternoon in docket number E7 sub 1283, which is the application by Duke Energy Carolinas LLC for approval of renewable energy and energy efficiency portfolio standard. With me today are Commission Chair Mitchell and Commissioners Brown, Bland, Duffley, Hughes, McKissick, and Kimmeray. I remind members of the commission of our duty under the State Government Ethics Act to avoid conflicts of interest and inquire at this time whether any member of the commission has a known conflict of interest with respect to this docket. Madam Court Reporter, please let the record show that no conflicts have been identified. Ladies and gentlemen, the expert witness hearing for this docket has been canceled by agreement of the parties and by order of the commission. So the sole purpose for opening the hearing this afternoon is to inquire whether there is any member of the public who wishes to present public witness testimony. And I'll call now upon public staff to advise whether any persons have come forward notifying you that they wish to present public witness testimony.
We have identified no witnesses for this docket.
All right. For good order's sake, I probably should have an announcement of appearances just for the record. So let's, before I jump the gun too far, let's do that, Mr. Kaler.
Commissioner Clodfelder, Robert Kaler, appearing on behalf of Duke Energy Carolinas.
Great. And on this side of the room, anyone? Just for purposes of the record, that's all.
Good afternoon, Menashe Magarira, appearing on behalf of North Carolina Justice Center, North Carolina Housing Coalition, and SACE.
Great, thanks.
Good afternoon, Marcus Trathan, appearing on behalf of the Carolina Utility Customers Association.
Good afternoon, Christina Kress, appearing on behalf of CPRE.
Nadia Lohr with the public staff. Also appearing with me is Ann Keyworth with the public staff on behalf of the using and consuming public.
Thank you. I have been advised by counsel that there are no known public witnesses, so let me inquire in the audience. Is any person here who wishes to provide public witness testimony with respect to docket E7 sub 1283, which is the application for approval of the REPS portfolio standard by Duke Energy Carolinas? Going once, going twice, and that's it. So with that, we will close the public hearing record. Parties are advised again that the expert witness has previously been canceled pursuant to order of the commission. Thank you.
Good afternoon. Let's come to order and go on the record. I am Commissioner Tanola D. Brown Bland of the North Carolina Utilities Commission and the presiding commissioner for this hearing. With me this afternoon are Chair Charlotte A. Mitchell, Commissioners Daniel G. Clodfelter, Kimberly W. Duffley, Jeffrey A. Hughes, Floyd B. McKissick Jr., and Karen M. Kimmeray. I now call for hearing docket number E7 sub 1285 in the matter of application of Duke Energy Carolinas LLC's annual review for approval of demand side management and energy efficiency cost recovery rider. GS 62-133.9 establishes the procedure for cost recovery of demand side management, hereafter DSM, and energy efficiency, hereafter EE, expenditures. General Statute 62-133.9D provides for an annual DSM EE rider for electric public utilities to recover all reasonable and prudent costs incurred and appropriate incentives for adoption and implementation of new DSM and EE measures. On February 28th, 2023, and corrected on March 7th, 2023, Duke Energy Carolinas filed its application for approval of its annual DSM and EE cost recovery rider, along with the direct testimony and exhibits of KCQ Fields and Shannon R. Lisberger in support of the application. On March 16th, the Commission issued its order scheduling a hearing requiring filing of testimony, establishing discovery guidelines, and requiring public notice. The order scheduled the hearing in this docket for today, Tuesday, May 30th, 2023, immediately following the hearings in DEC's, or Duke Energy Carolinas, other annual cost recovery riders, the first of which was scheduled to begin at 2:00 p.m. Based on their timely petitions to intervene in this docket, the following parties were allowed to intervene by order of the Commission: Carolina Utility Customers Association, Inc., Carolina Industrial Group for Fair Utility Rates 2, and jointly North Carolina Justice Center, North Carolina Housing Coalition, and the Southern Alliance for Clean Energy. The intervention and participation of the public staff is recognized pursuant to statute GS 62-15D and Commission Rule R1-19E. On April 28th, 2023, DEC filed the supplemental direct testimony and exhibits of Carolyn T. Miller, which adopted the testimony and exhibits of witness Liz Barger and Casey Q. Fields. On May 9th, the public staff filed testimony and exhibits of David M. Williamson and Hemant Mehta. On May 26, 2023, DEC filed the proposed direct testimony of Carolyn T. Miller and a motion for leave requesting that Miller be allowed to adopt the previously filed direct testimony of witness Liz Barger. On the same day, the commission granted the motion accepting the testimony and exhibits of witness Miller. In compliance with the requirement of Chapter 163A of the State Government's Ethics Act, I remind the members of the commission of our responsibility to avoid conflicts of interest. And I inquire at this time as to whether any member has any known conflict of interest with respect to the matter before us this afternoon. The record will reflect no conflicts were identified. And now I'll call for appearances from beginning with the applicant.
Good afternoon. My name is Kendrick Fentress. I'm appearing on behalf of Duke Energy Carolinas this afternoon.
Thank you, Ms. Fentress.
Good afternoon. My name is Ann Keyworth. I'm appearing with Nadia Lohr on behalf of the public staff.
Thank you.
Good afternoon, Menashe Magruder, appearing on behalf of North Carolina Justice Center, North Carolina Housing Coalition, and Southern Alliance for Clean Energy.
Good afternoon, Marcus Trathan, appearing on behalf of Carolina Utility Customers Association.
Good afternoon, Christina Kress, appearing on behalf of Siegfried 3. And just for clarity of the record, Siegfried 3 was granted intervention in this docket. Thank you.
All right, thank you for that correction. The record will so reflect. All right. So are there any preliminary matters before we begin?
I do have one, Commissioner Brown-Bland. It is my understanding that the parties have no cross-examination for the Duke witnesses and also for the public staff witnesses. With that being the case, the company jointly with the public staff, if they are agreeable, would move that those witness testimonies be entered into the record and the application be entered in as well.
All right, there being no objection, the witness testimonies earlier mentioned by me on behalf of the company and on behalf of the public staff will be received into evidence at this time, as well as their exhibits. They will be treated as if they were given orally from the witness stand. And the exhibits will be identified as they were marked when pre-filed.
Thank you.
All right. So at this time, I'll ask if there are any public witnesses. Has public staff identified any public witnesses?
No, there are no public witnesses.
And just to be clear, in the matter of the DSM EE rider, are there any witnesses in the audience who wish to be heard as a public witness? Seeing none coming forth, the record will reflect that no public witnesses came forward. All right. And before I go any further, the evidence has already been received. It's just for the record, ask if any commissioners have any questions of any witness. All right. That being taken care of, that brings us down to proposed orders. There is 30 days from the date of the availability of this transcript sufficient?
That will be sufficient for us. Thank you.
All right, it'll be so ordered. There being nothing else in this case, this matter will be adjourned. Thank you.
Good afternoon. Let's come to order and please go on the record. I am Kimberly W. Duffley, and with me today are Commission Chair Charlotte A. Mitchell and Commissioners Tanola D. Brown-Bland, Daniel G. Clodfelter, Jeffrey A. Hughes, Floyd B. McKissick Jr., and Karen M. Kimmerite. I now call for hearing at this time, docket number E7 sub 1281, which is the application of Duke Energy Carolinas, or DEC, for approval of the CPRE Cost Recovery Rider and the 2022 CPRE Compliance Report pursuant to North Carolina General Statute Section 62-110.a and Commission Rule R8-71. On February 28, 2023, DEC filed its application for approval of the CPRE Cost Recovery Rider and the 2022 CPRE Compliance Report, along with the testimony and exhibits of Angela M. Tabor and Christy J. Walker, portions of which were filed as confidential. On March 16, 2023, the Commission issued an order scheduling a remote hearing requiring filing of testimony, establishing discovery guidelines, and requiring public notice. Timely petitions to intervene in this docket were filed by the Carolina Utility Customers Association Incorporated, hereinafter KUCA, and the Carolina Industrial Group for Fair Utility Rates 3, hereinafter SIGFR 3. The Commission granted these petitions to intervene. The intervention and participation by the public staff is recognized pursuant to North Carolina General Statute Section 62-15. On April 24, 2023, SIGFR 3 caused to be filed a notice of appearance for Douglas Conant. On April 3, 2023, DEC filed supplemental testimony and exhibits of Angela M. Tabor and Christy J. Walker, parts of which were pre-filed as confidential. On May 13, 2023, the public staff filed the direct testimony of Darius K. Cofield, Public Utility Regulatory Analyst, Accounting Division, and Jeff Thomas, Engineer with the Energy Division of the Public Staff, portions of which were pre-filed as confidential. On May 18, 2023, DEC filed the rebuttal testimony of Angela M. Tabor and Matthew Holstein, portions of which were pre-filed as confidential. On May 23, 2023, the public staff filed a motion for substitution of witness and adoption of testimony, and the testimony of James S. McLaughlin, portions of which were pre-filed as confidential. On May 24, 2023, DEC and public staff filed joint motion to excuse witnesses Christy Walker and Darius Cofield, which was allowed by commission order on May 26, 2023. Today, on May 30th, 2023, the public staff filed the updated confidential version of the testimony of James S. McLaughlin so that the record may accurately reflect the public and confidential information within his testimony. In compliance with the State Ethics Act, I remind members of the Commission of our responsibility to avoid conflicts of interest and inquire at this time whether any member has a known conflict of interest with respect to the matter before us in this proceeding. Let the record reflect that no conflicts have been identified. I now call for appearances of counsel.
Good afternoon. Thank you. My name is LaDawn Toon, Associate General Counsel on behalf of the applicant, Duke Energy Carolinas, LLC. Thank you.
Good afternoon.
Good afternoon, Presiding Commissioner Duffley, Commissioners Brett Reichler with the law firm McGuire Woods on behalf of the applicant. With me today are Kristen Athens and Mason Maney, also with McGuire Woods.
Good afternoon.
Good afternoon, Commissioner Duffley and members of the commission. Tom Felling and Robert Josie with the public staff here on behalf of the using and consuming public.
Good afternoon.
Good afternoon, Marcus Trayton on behalf of the Carolina Utility Customers Association.
Good afternoon.
Good afternoon, Christina Kress here on behalf of SIGFR 3.
Good afternoon. Any other appearance? Are there any preliminary matters before we begin?
Commissioner Duffley, just very briefly, the company has confirmed with the public staff and with counsel for Cook and SIGFR, and no parties have examination for the company's direct case. And so the rebuttal panel of witnesses, Holstein and Tabor, we would plan to present after the public staff case. And at that time, we would also present the direct and supplemental testimony of witness Tabor, if that's acceptable to the commission.
That's acceptable.
Thank you.
No objections to that. Okay, any other preliminary matters?
Just for clarification, we had a pending motion to substitute James McLaughlin for Jeff Thomas and wanted that needed commission attention at this time. That's right.
It does, and without objection, that motion will be allowed.
Thank you.
And moving to public witnesses, Mr. Josie or Mr. Felling, have you identified any public witnesses that wish to present testimony this afternoon?
We have not.
Is there anyone present in the courtroom that wishes to present public witness testimony? Okay, please let the record reflect that no one came forward to testify. So with that, I would say that the case was with the applicant, but I think that how y'all have agreed to presentation of the witnesses, public staff.
Thank you, Commissioner Duffley. The public staff now calls James McLaughlin to the witness stand.
Well, we need to go into recess for 1 moment. We're off the record. Okay, left hand on the Bible. Raise your right. Do you swear that the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. McLaughlin, would you please state your name, your business address, and your current position for the record, please?
James S. McLaughlin. My business address is 430 North Salisbury Street, Raleigh, North Carolina, and I'm the director of the Public Staff's Energy Division.
Are you aware that on May 9th, 2023, public staff witness Jeff Thomas prepared and caused to be pre-filed direct testimony in this docket consisting of 17 pages and one exhibit?
Yes.
And was that testimony and exhibit prepared with your knowledge and under your supervision as Mr. Thomas's supervisor?
Yes, it was.
And are you aware of any changes or corrections to that pre-filed direct testimony?
I am not.
And on May 23rd, 2023, did you adopt Mr. Thomas's pre-filed direct testimony and exhibit as your own, and through counsel move the commission to be substituted as a witness in place of Mr. Thomas for the purposes of this hearing?
Yes.
On May 30, 2023, did you file an update to that pre-filed direct testimony to ensure that the record accurately reflected the public and confidential information in your testimony?
Yes.
Do you have any changes or corrections to that pre-filed direct testimony?
No, I do not.
And if you were asked those same questions today while testifying from the witness stand, would your answers be the same?
Yes, they would.
Commissioner Duffley, at this time, I move that the pre-filed direct testimony of public staff witness James McLaughlin be entered into the record as if given orally from the stand, and that McLaughlin Exhibit 1 be marked for identification as pre-filed.
And my papers have, there's an Appendix A as well. Is that accurate?
Yes, thank you.
Okay, and you want to mark that?
Yes, please. Thank you.
Okay. So the direct testimony of James McLaughlin containing confidential information filed on May 30th, 2023, consisting of 17 pages, will be copied into the record as if given orally from the stand, and Appendix A and Exhibit 1 will be marked for identification as they were when pre-filed.
Thank you. Mr. McLaughlin is now available for cross-examination.
No cross?
No cross from the company, although we reserve the right to ask questions if the commission has questions.
Okay. Any commissioner questions? Chair Mitchell.
Good afternoon, Mr. McLaughlin. Just a few for you. With respect to liquidated damages, your testimony, as I understand it, indicates that the SPE would be responsible for payment of the liquidated damages because it would be the contracting party. Is that correct? In this case, it would be Wilkes Solar that you all had investigated.
Well, it would be Wilkes Solar or their designee. And in this case, they had their parent company, DESRI, I'm not exactly sure how you pronounce it, was the party that they had designated as responsible or as the guarantor.
And I just want to make all the parties aware there's confidential information in this case. I don't know if the name of the company is confidential or not, but the commission's going to be relying on the parties to indicate when we need to go into confidential session on these questions.
Thank you, Nick.
Commissioner Duffley and the company will correct me. My understanding is that the only confidential portion of my testimony are the actual dollar amounts that were involved. Now, the company will correct me if that's not true.
That's generally correct based on the efforts of the public staff to refile Mr. McLaughlin's testimony.
Okay, thank you.
And my questions, I don't intend to elicit confidential information. I just want to ask about process more and am not as interested at this point in the actual numbers. But you all, the public staff provides testimony about the challenges that the company might face in attempting to recover liquidated damages from Wilkes Solar. Do you recall that testimony?
Yes, in this particular case, because there's a dispute among the parties as to who was responsible for delays of which the public staff is not taking a position, and then because of the expiration of the guarantee.
Okay. You also provide some testimony regarding additional liquidated damages that the company had recovered related to another project. Do you remember that testimony?
Yes.
Okay. So are you aware of whether the company has had problems or encountered challenges recovering liquidated damages from market participants other than Wilkes Solar?
I am not aware that they have. I mean, I don't know exactly, how difficult it was, but they have reflected a number of instances of liquidated damages, both in this case and in a prior CPRE case in which they did recover liquidated damages.
Okay, so the public staff isn't concerned that given the contractual terms and conditions related to liquidated damages, that the company would encounter unnecessary or unreasonable challenges in recovering those liquidated damages when it needed to?
At this point, I don't have any reason to believe that in general.
Okay.
There are some particular issues with this one PPA that was signed.
Okay. What can you tell me, if anything, about the expiration on the guarantee in this case? Is it typical that there be an expiration date on a guarantee? And if so, was the term of effectiveness of this guarantee sort of commercially reasonable?
My reading of the documents is that it is not required that there be a termination date, but there's an Exhibit 6 to the purchase power agreement that the seller signs and they can place an expiration date in there. We have, or I have reviewed in this case, a number of signed and executed PPAs, and this is the only one I have seen that actually had a date inserted there. The others, at least what was provided to us by the company, it was left blank.
And when you say a date inserted, a date, what type of date and inserted where?
An expiration date for the guarantee. Now it's very clear in the provisions that the seller must maintain a form of guarantee to protect the company and to protect the company's ratepayers in the event of default. And if there is an expiration of that, then the seller, which is Wilkes Solar in this case, must make provision to provide replacement guarantee, whether it would be an extension of the current guarantor or it would be some other provision. The issue in this case, as I see it, the PPA was signed on October 15th of 2020, and the guarantee by I'm going to just call it DESRI. I don't know if that's the correct pronunciation, was designated to expire on December 31st, 2021, which was just a little over 14 months after the PPA was signed, which is in the grand scheme of these CPRE projects is a very short time frame. In fact, the company itself has stated, and company witness Cathcart in the 2021 CPRE proceeding filed supplemental testimony. And in that, he said that the DEC did not expect any of the Tranche 2 projects, the winning projects, would achieve commercial operation in less than 24 months from the time that the interconnection agreement was signed. And here we've got just a little over 14 months from the signing of the PPA, and it's about another 6 months until you get the interconnection agreement. So certainly there was a provision for Wilkes to replace that guarantee, but in my mind, such a short period of time, that should have been a red flag to the company.
Okay, thank you for that additional information. That's helpful. And the company has provided some testimony about some IT fixes that it's looking into to try to prevent this type of situation going forward. And indicated also, as at least my read of the testimony, is that this was an unusual occurrence, the failure of this information to be keyed into its system. But my question for you is, did you all do any thinking or discussing, and by you all, I mean public staff and the company, about other types of either requiring financial assurance to be in place for a longer period of time or indefinitely, and perhaps requiring certain types of financial assurance that wouldn't expire, like cash in the bank or some other type of more liquid assurance?
Well, the short answer to your question is no. There is nothing wrong with the type of assurance that Wilkes provided under, well, let me back up on that. The type of assurance that Wilkes provided was provided for through the CPRE process. So it was an acceptable form of guarantee. The issue with me is the short time period, why that wasn't questioned up front.
Okay. Switching gears just a little bit, and I think Commissioner Duffley has questions for you on this topic, so I will just ask you a few. You all provided, public staff provided testimony regarding the number of projects that have withdrawn from the CPRE tranches. And I guess, and all of those projects were to be located in DEC service area.
The vast majority were, yes.
Can you give us any, what can you tell us about why those projects have withdrawn from the CPRE?
Let me get my schedule out.
Mr. McLaughlin, do we have that schedule? Is this your
No,
personal
this was not
schedule?
something I prepared for
Okay, thank you.
testimony. I'm certainly happy to make it available to the commission if you'd like to have it. It is a list of winning projects from tranche 1 and tranche 2 and of the CPRE and what their current status is. And so for tranche 1, I see 10 projects, and there are 2 that currently the PPA has been terminated prior to commercial operation. In tranche 2, I also count 10 projects, and of that, 5 of the 10 have terminated prior to commercial operation.
So what can you tell us about, I mean, what do you know about why these projects have terminated their PPAs?
We don't always know the exact reason. I think in the case of Wilkes, they said that the delays, and again, not taking sides for who was to blame, but they're saying the delays in getting the interconnection or in getting the upgrades, the interconnection facilities in place had caused the project to no longer be financially viable. So the delays, the costs have gone up, that sort of thing. And I probably this would be speculation. I think some of the projects may have seen the opportunity to withdraw and bid into the 2023 solicitation for carbon plan projects, but that's speculation on my part. I don't know that for a fact.
Okay. So I think I recall testimony in Duke's rebuttal on Wilkes Solar, and I may be misremembering this, but regarding Wilkes Solar's participation in solicitations conducted by the company going forward. Do you remember testimony to that effect?
Yes.
That it would be that Wilkes Solar would be precluded going forward?
Yes.
Is that,
I remember that.
do you and I understand that testimony the same way?
I think so.
Okay,
Yes.
does the public staff agree with that position the company's taken?
We have concerns about that. I think that maybe that, again, we're not negotiating directly. So I defer somewhat to Duke on that, but if we start eliminating bidders, that may, it's possible it could have a chilling effect on some of the bids. That doesn't mean there aren't some individual bidders that maybe that are not warranted, but I hesitate to make a blanket statement. Yes, cut them out. Don't let them bid anymore. I do have concerns about that.
Okay. Does the public staff have concerns about these withdrawals from the CPRE tranches and the sort of the lack of solar being placed in service during certain time periods as the company has planned for with respect to, you know, procurements and procurement targets that have been established for 22, 23 and going forward? And just to be clear with my question, I mean, the company was planning for certain levels of solar to be in service by certain dates, and now we're seeing these withdrawals from CPRE, which is necessarily going to affect these levels of solar that the company had been planning for. What do we do about that?
Well, it is definitely disappointing that within the CPRE, with the number of winning bids that have withdrawn, because as the commission is aware, those bids were selected because they were below avoided cost. And so that was going to be a direct savings to customers in the solicitations going forward to meet the requirements of the carbon plan. There's no such requirement that the bids have to be below avoided cost. And as a result, I mean, I don't think you actually have to be a genius to figure out the bids are probably going to be higher than that. So whether it's going to be a problem with bidders withdrawing in the future, if they withdrew solely so they could rebid in the future solicitations and get a higher price, then there's no particular reason to think that they will withdraw again. But again, that's requiring some speculation. But yes, it's disappointing, the results, no question.
Right. Right. And, all right, I'll just leave that alone for now. Let's see. I think that covers me, Mr. McLaughlin, but let me just go back through my notes to make sure. I did note your testimony on network upgrades, and you all noticed a slight increase in costs and network upgrades. Do you want to, anything else that you want to say about that, or any concerns beyond what you've stated in your testimony?
I don't think we consider it to be a slight increase. It's pretty significant.
Okay.
And it's just something that we'll be monitoring going forward, but I don't really have public staff doesn't have anything further to say about it at this point.
And just for purposes of refreshing recollection, am I correct that in the CPRE paradigm, network upgrade costs are imputed to the bidder for purposes of that avoided cost threshold?
I believe that's
Okay.
correct, yes.
Okay, thank you, Mr. McLaughlin. I have nothing further.
Commissioner Brown Blair, Commissioner Cloudfelter.
Mr. McLaughlin, I've got a couple of follow-up questions on a topic that Chair Mitchell opened with you. And just to follow along with me, you might want to look at page 11 of your testimony, where you quote from section 5.7 of the Tranche 2 PPA. You have that?
Yes.
I also have the full PPA in front of me, but I think you've quoted it correctly. The PPA requires that the term of the performance assurance extend until 60 days after the later of the expiration of the term or the date on which the seller has fully satisfied all obligations to buyer under the agreement. You see that?
Yes.
That's consistent with your understanding of what the PPA requires.
Yes.
And subject to check, and I think you confirmed this when your answer to Chair Mitchell, the guarantee given in this case did not comply with that provision of the PPA, did it? It expired on the earlier of a date certain or the date on which Wilkes Solar had fully satisfied all obligations under the agreement, correct?
Yes, but my understanding is that had Duke notified the seller in advance, they would have had the opportunity to extend the date, and that would have satisfied this requirement. That's my understanding. I'm not an attorney knowing all the nuances of legal documents, but that's my understanding.
I'll get to the notice question in just a minute, but at least on its face, the guarantee that was delivered did not conform to section 5.7 of the PPA, correct?
I guess hindsight, it didn't. I mean, it's difficult. It's difficult to know going in when the commercial operation date is going to be. So I'm not.
Which is why Duke asked for a performance assurance that protects it against that very risk, isn't it?
Yes.
Well, in the course of your review of the matter, did you develop any understanding as to why in this particular instance, Duke did not require compliance with section 5.7 of the PPA?
Duke was unaware that it was expiring because they did not enter the date in their tracking system when they put the information about this PPA in there, so they never were notified.
Mr. McLaughlin, I'm asking a slightly different question, not about the clerical error in missing the expiration date, but about the front end acceptance of the guarantee as being sufficient. Did you come to any understanding about why Duke accepted the guarantee in the first place?
No, I didn't. And as I responded to Chair Mitchell, that was would have been a red flag to me that this was in there and for such a short period of time if I had been in Duke's shoes.
Do you know whether this guarantee received any special review by credit department or by legal department at Duke?
The testimony of Duke indicates that they do review, their legal and credit departments do review this. I can't testify as to this specific PPA. I think that's their general practice.
I understand the testimony about the general practice. I was just trying to figure out what you may have discovered, if anything, in the course of your review of the matter about this specific case.
I do not know.
Okay, thank you. I do want to look with you again at Exhibit 1 to your testimony, and I believe I had it marked here a minute ago, so I'm going to flip back again. It's Exhibit 1, Annex D, page 31 of 37. That's the form of surety bond that Duke has prescribed as acceptable.
Yes.
And if you look with me at the bottom of that page, 31 of 37, paragraph 5, and we can both read. I'll save you the trouble and read it for you. It says that the obligation is effective at the beginning of the surety bond effective date, provided that if the bond remains in effect after 1 year following the surety bond effective date, the bidder may cancel the bond after such 1 year period by giving Duke Energy at least 45 days prior written notice of the cancellation date. You see that language?
Yes.
From your investigation of this matter, did you make any determination about whether or not any notification was provided to Duke Energy prior to the expiration of this guarantee?
Our investigation indicated that there was no additional notification provided to Duke. Duke did not discover that it had expired until after the expiration date.
You would agree with me that this provision of this exhibit contemplates that the notice is to be provided by the party seeking to cancel, and that notice should go to Duke, not come from Duke, correct?
Correct.
Thank you. That's all I have.
Just a couple of questions, just following up on a similar line of questions asked by Chair Mitchell and from Commissioner Clotfelter. When I look back to this original power purchase agreement, it looks like it was executed on or about October 14th of 2020. Is that right?
I had October 15th, but I could be off a day.
Yeah, well, 14th, 15th, thereabouts. And of course, attached to it, I think it was as Exhibit 6 was this, what I would call standard form guarantee type agreement.
Yes.
And on that particular form, if you look to the, I guess, the time frame within which the guarantee would be effective, it does not provide a date, a term of guarantee. I guess it's Section 11.
It does not, but if you, the company in their rebuttal testimony provided on Exhibit 2, which is that same form, and it does include the December 31st, 2021 date.
But that particular document that you're referring to, and I have a copy of it, that wasn't executed until a week later, was it? Wasn't that executed on or about the 21st of October, whereas the agreement itself was executed about a week earlier, about the 14th or 15th?
That may be true. Okay, it does, that document does actually say October 21st, that particular document.
Therefore, one could reasonably conclude that when the power purchase agreement was executed, there was not a contemporaneous guarantee agreement executed and provided at or about the same time that would have had that termination date. Would that be a correct assumption to reach?
I'm not sure. It does reference in the background statement, it references the PPA dated October 15th. But you're right, the guarantee agreement
Is a week
above
later.
does say October 21st. of
Now, do you
2026.
know whether it's typical in these type of transactions, if a guarantee is provided, that the guarantee would come in a week later, as opposed to being provided and executed, delivered at or about the time the power purchase agreement was executed?
I would not have thought so, but I don't know. I did not ask Duke that particular
You
question.
didn't ask Duke
I
that
did
question.
not.
And as it relates to the reason that this project did not move forward, did you make any inquiries of Duke or Wilkes as to why they decided that they would abandon the project?
We did not talk to Wilkes Solar, since the PPA was already terminated. We had the information provided by Duke that there was a dispute about who was responsible for the delays. And Wilkes said it was Duke's fault, and Duke said it was not. And nevertheless, the Wilkes had indicated that they wished to terminate the PPA.
All right. So other than just having those conversations with Duke, that was the extent to which you made inquiries about the reason that the project did not move forward?
Yeah. We didn't reach out to Wilkes. I don't know that they would have been obligated to respond to the public staff since there was no longer an agreement with Duke in place.
But other than conversations with Duke, that would have been the extent of it.
Yeah, Duke's the only other party involved.
I think that probably would be the extent of questions I would have. I think other things would get into the actual numbers. So I'm going to avoid doing that to avoid going in a confidential session. Thank you.
Okay.
Good afternoon. So I'm just going to ask the question one more time about any further explanation as to why the CPRE program has experienced significant delays, withdrawals, and terminations.
No, I mean, I could speculate, but I don't think the sellers are obligated to say why they withdraw.
Okay. And so could we talk about, you mentioned the 2023 solar procurement, but I'd like to go back to the 2022 solar procurement. What are the material differences between just material differences in the PPA from the CPRE process and the 2022 solar procurement process?
I was not prepared to answer that question. I am not aware of any particular differences between the two. I'm sure there are some.
Okay, and I'll ask, maybe I'll ask the company, but would you agree, subject to check, that that year terms may be different? CPRE has a 20-year term, and the 2022 solar procurement has a 25-year term.
Yes.
Are avoided costs going up or down?
Well, we'll soon find out. But I would say that they're probably going up.
Okay, and then you mentioned when Chair Mitchell was asking you questions in tranche one, we had 10 projects that were awarded contracts. 2 PPAs have been terminated. Do you have on your chart the amount of megawatts?
Yes. One, first one, this is tranche one.
Correct.
Oakboro, and that was 40 megawatts. I'm sorry, maybe I wasn't supposed to say the name. And then the other one that was terminated was 75 megawatts.
And just total megawatts for tranche two, you stated that 5 PPAs have been terminated.
Yes.
I'm gonna make you do math. Approximately what's the total megawatts that have fallen out of the second tranche?
Okay. Approximately 300 megawatts.
Okay. And then I am going to request if it needs to be confidential, late filed exhibit to really gain an understanding of the total CPRE generating capacity that have been adjusted for project terminations. So what is the total CPRE program generating capacity under project? Both in service and in development for both DEP and DEC, as well as the PPAs, the same information for the PPAs that have been terminated. And then a breakdown of total contracted generating capacity by each tranche, as well as termination by tranche, if you would.
Okay.
Thank you. So public staff is seeking an adjustment that the amount of the adjustment's not confidential, correct?
No, I think it is.
Oh, I mean, not the dollar amount, but the percentage.
No, that's not confidential.
So the public staff seeking DEC to credit 50% of the liquidated damages that it could have obtained. What authority is public staff using to seek this adjustment?
Well, while there is no way to know for certain that Duke would have been able to collect the liquidated damages, the fact that the guarantee was allowed to expire without Duke notifying the customer that they were in default if they didn't extend it, sort of removed any possibility of being able to attempt to recover the liquidated damages. So because we couldn't know with 100% certainty that Duke would in fact have been able to, we thought some lesser amount than the full amount was appropriate.
Okay, and are you saying or asserting that DEC has acted imprudently? I'm just trying to gain knowledge or information about what the standard is that public staff was using.
Well, I think that I believe that by allowing this such a short clearly Duke said they made an error by not entering the expiration date in their tracking system, in which case they would have been notified that it was about to expire. But I have concerns that they ever allowed such a short date to be put in place to begin with. To me, that should have been a red flag for the company.
And again, but are you stating this error is rises to the level of imprudent behavior?
I believe that the company should have been more diligent in their efforts when they were signing this PPA and the guarantee.
And so let's talk about liquidated damages. What's your understanding? I read your testimony about some of what you think liquidated damages are for, but can you state again to me, what do you think the liquidated damages represents in these contracts?
It's a protection for both the company and ultimately the company's customers against default. Duke is going to have to replace, in this case, the capacity of Wilkes Solar, and it'll be replaced through the future solicitations, and I believe it will be at a higher cost. So there is harm that has occurred to Duke's customers, and the liquidated damages would have helped offset a portion of that. In fact, we did calculation of the benefits that would have accrued to customers from this particular PPA over the 20-year life and brought it back to a net present value basis. And that would have been approximately equal to the liquidated damages. So if Duke had been able to recover those, customers would have essentially been held harmless.
Okay, and then how do you respond to DEC stating in their rebuttal testimony that it's speculative to assume that but for the data entry error, DEC would have recovered the amount in liquidated damages from Wilkes Solar?
Well, my response is we're not assuming that they absolutely would have. We don't know. The failure to recognize the expiration date has removed that possibility. They could not have recovered those because they missed that.
Okay, and do you think the fact that the seller did not maintain performance assurance for the duration required by the agreement, is the seller in default for that failure?
I believe they are, and had Duke notified them before the expiration of the guarantee, if they had refused to extend the guarantee, then Duke, my understanding is Duke would have had a legal claim for the seller being in default. And it would have strengthened their case.
Okay, thank you. And so I'm going to go a little off topic with the carbon plan. So we have stated a target amount in the carbon plan for solar, correct?
Yes.
And do you remember what that is? It's subject to check. Is it 2,350 megawatts?
That sounds correct.
And so is the baseline, what amount of the CPRE program contracted megawatts was considered in the carbon plan as a baseline for the establishment of the procurement number of 2,350, if you know?
I don't recall exactly how the CPRE numbers factored into that, but just for instance, if Duke had assumed at the time that Wilkes Solar or any of these other projects that were terminated in Tranche 2 were going to be operational in commercial operation, that would either have reduced that number or if they assumed that they weren't going to be in operation, then the amount of megawatts that have to be procured would increase. Now, whether the 2,350, I believe it was, whether that includes an assumed amount of termination within the CPRE or what level of termination, PPA terminations it assumed, I'm not certain at this time.
Okay, thank you. And so the commission has obviously issued a CPCN to Wilkes Solar. What, if anything, do you think the commission, I heard you testify, you felt that Wilkes Solar has defaulted in one way or another on this PPA. So what, do you have any recommendations for the commission as to what to do with respect to the CPCN as it relates to this case?
I don't know what Wilkes Solar's future plans are for that CPCN. Certainly the commission, I think, would be in its rights to revoke the CPCN if you felt that you no longer had confidence in Wilkes Solar's ability to complete the project. I don't have any particular knowledge of Wilkes Solar or their parent company's financial viability and intentions in the future. So, I mean, I hesitate to start making recommendations about this project terminated, bar them from participating in any future RFPs. This one did bar them because after a while you're limiting your pool, which is going to drive costs up.
Thank you for that. I think one last question. So on page 27 of DEC's rebuttal, they indicated that the public staff's adjustment in this case is not a typical adjustment. And I just wanted to obtain your response to that. Do you agree, disagree? Would you like to speak to it?
Can you point me to the exact line?
Sure.
I've got the rebuttal.
It's on page 27. I'm trying to do everything electronically, so you'll have to bear with me.
Okay, I see it. It's on line 19. Well, they go on over to page 28, which is all part of the discussion, and say there will not be any direct replacement power costs for the lost energy production anticipated to be delivered by Wilkes. And I guess I disagree with that statement because the capacity and the generation from it will have to be made up somewhere else. I mean, in order to meet our carbon reduction goals. So there will have to be another project or some other effort that makes up the cost that or the generation, the energy that Wilkes Solar was going to produce, and that's going to have a cost, and we expect that that cost will be above avoided cost at this point, or is likely to be.
Okay, any follow-up on my questions? Okay, questions on, thank you for your testimony. Questions on commission questions?
Just have a few. Good afternoon, Mr. McLaughlin.
Good afternoon.
I want to start with a couple of questions that Commissioner Mitchell, or really just one line of questions that Commissioner Mitchell asked you, or Chair Mitchell, excuse me, asked you at the outset. So she asked you if, based on the public staff's investigation, this was, and the quote I have is an unusual occurrence. Do you recall that line of questioning?
Yes.
And based on the public staff's investigation, isn't it a fact that you did not identify any other purchase power agreements where the company had security that was not able to be exercised upon in the same manner that's occurred with Wilkes Solar?
We did not discover any others, but I would say that we did not discover any other PPAs that had been signed that had such a short expiration date for the guarantee as Wilkes Solar.
Excuse me, I spoke. Did you specifically audit for that? Did you ask that discovery?
We asked for copies of the PPAs from the company, and the ones that were provided to us did not have expiration dates.
And could that be because those other counterparties submitted letters of credit versus parent guarantees?
It could be.
Okay.
That doesn't change the fact that Wilkes Solar was a very short period of time, and there was no way that it was going to achieve commercial operation before it expired.
I appreciate your opinion on that, but would you agree that your role as the public staff, I think the question we asked earlier was whether it was commercially reasonable to accept that term of guarantee? Would you agree that's not within your core area of expertise to evaluate the term of guarantees or other security instruments to determine whether they're commercially reasonable?
We are not involved in the negotiations between the company and sellers.
Thank you.
That's correct.
So turning to some questions that Commissioner Mitchell and Commissioner Duffley have about whether Wilk Solar should be allowed to bid into future Duke RFPs. You recall those?
Yes.
And you seem to be, in my paraphrasing, of two minds of it. It's unfair for them to not meet their obligations under this PPA, but at the same time, you had some concerns about limiting the pool of potential counterparties. Is that fair? Potential sellers and or
Yes.
bidders in the RFP. Do you think this is a topic that the company and the public staff should explore as part of the 23 RFP to make sure that we have effective terms of security in place and to minimize the risk of this type of circumstance happening again?
I think we would definitely like to minimize the risk of this happening again, and public staff is always willing to work with the company.
Great. And there's a comment proceeding that's open now to provide comments on the contract documents and that RFP, and we've been working constructively with the public staff through that process.
Yes.
Great, thank you. Commissioner Clodfelter asked you a few questions about section 5.7 of the PPA. You recall that?
Yes.
And at the risk of a second lawyer asking a non-lawyer a question about a contractual provision in a power purchase agreement, I'm going to take a run at it because it is in your testimony. Would you mind? I think it's on page 9.
I'm there.
All right, thank you. Excuse me, page 11.
Page 11.
And so just reviewing this provision, would you agree that the intent of the provision is to ensure that performance assurance remains, and I quote lines 21 to 22, shall remain in full force and effect and outstanding for the benefit of the buyer until, paraphrasing, the end of the term?
Yes. Or the date on which the seller has satisfied all obligations.
Thank you. And so there's nothing prescriptive in the agreement that suggests that a single security instrument needs to cover the full duration of the contract term.
Can you ask that again? I'm sorry.
Sure. So turning to page 12, line 2, it contemplates, or line 1 and 2 contemplates the potential for replacement performance that the counterparty shall replace such performance assurance with alternative performance assurance that meets each of the requirements under this agreement. So would it be reasonable to expect that the company could accept a security instrument with the understanding that that might expire within the term, but as long as it was replaced contemporaneous with or in advance of when that security instrument expired, that would be reasonable and consistent with this provision?
It's reasonable. It would have, I suppose it would have been reasonable if it had expired a week after it was, if there was a date that was a week after it was signed. It doesn't seem like it would be something that would, the company would want to enter into, but you could certainly read it that way.
Thank you. And Commissioner McKissick asked you some questions about the timing of the company accepting the pre-COD performance assurance, and seems to be focused on that timing relative to execution of the PPA. Do you recall that?
Yes,
And I believe you have a copy of the PPA with you.
I do.
Okay, if you just briefly turn to section 5.1 and review that section, just the first 2-3 lines of it, please.
It's titled Pre-COD Performance Assurance Requirements.
Yes, sir.
Did you want me to read that out loud or just read
Let's
it?
review it. And if you'd agree that it provides that the company can accept from the counterparty performance assurance within 5 business days of when the contract is executed.
Yes, it does say that.
Thank you. No further questions. Appreciate it, Mr. McClellan.
Redirect.
Just a McLaughlin, a few of the questions, in response to a few of the questions you were asked from commissioners, but Commissioner or Chair Mitchell's question comes to mind about the term of the guarantee. And your response was that it was a red flag for you, that the term of the guarantee. Can you just expand on that? Why was that 14-month term a red flag in your mind?
Well, I mean, I would wonder why, knowing that based on the company's own testimony, it was going to take 24 to probably 30 months for the project to become commercially operational, why the company would want to accept a term that was so short, unless the company had provided for some other form of guarantee to take its place.
Do you know, have you reviewed the RFP that has been issued in the CPRE RFP tranche 2?
I've reviewed it. I don't have it memorized.
Okay. And to your knowledge, is there an expectation contained in that RFP on when a solar or a project would have the expectation of reaching commercial operation at the very earliest? And if you could, if it will help, this is on, you have the RFP attached to your testimony. If you turn to page 17, actually page 19 of 37 of your exhibit, if you look at the interconnection timeline, that might refresh your memory.
Yes, it says typically an interconnection agreement is achieved 4 to 6 months after the system impact study, and then commercial operation of the interconnection facilities is achieved 18 to 24 months after execution of the interconnection agreement. And as I mentioned before, in the 2021 CPRE case, DEC's witness Cathcart stated in his supplemental testimony that the Tranche 2 projects would require approximately 24 months from the IA execution to achieve commercial operation.
And thank you. You went to exactly where I was going to go to with that. To your knowledge, on reviewing everything that you've reviewed in preparation for your testimony today, at the time that witness Cathcart's testimony was filed, and you can give that date, but do you know if DEC reached out to Wilk Solar to discuss that?
Objection. I think none of the commissioners raised any questions about the CPRE Tranche 2 RFP, and this is the second question in this line that's focused on something that's beyond the scope of Commission's questions.
And
Mr. Felling.
Commissioner Duffley, this is directly in response to the question that was asked about the reasonableness of the guarantee and the term that was asked, and his response to the red flag. This is just further expanding on that.
Okay, Mr. Bragshort, I'm going to allow it.
Could you ask the question again?
Just in terms of at that time that testimony was filed, do you know whether DEC reached out to Wilk Solar to discuss whether that performance assurance would be renewed?
I don't. The testimony, the supplemental testimony was filed on May 3rd, 2021. As I mentioned, the PPA was signed October 15th, and I believe as Commissioner McKissick pointed out to me, the guarantee was signed on October 21st. So it was just a few months after the guarantee when was executed, when Mr. Cathcart filed his testimony, but I don't know that they reached out to Wilkes at that time.
Okay. And in response to Commissioner Duffley's question that you received on the authority to make the adjustment that you made, would you agree that the implementation costs that DEC is seeking to recover in this case and all CPRE rider dockets assume that the program would interconnect and provide energy to the using and consuming public?
Yes, and in fact, there have been costs incurred by the company for this and other projects that have already been recovered from ratepayers, administrative costs, legal fees.
Is it your understanding, and following up on that, is it your understanding that liquidated damages and the PPA are there to help defray some of those implementation costs?
Yes.
The project does not come on.
Yes.
No further questions.
And actually, while I was listening, I have one more question for you, Mr. McLaughlin. So getting back to the amount of megawatts that dropped out of or terminated tranche 1 and tranche 2, it was estimated maybe 375 megawatts or 400 megawatts. Would you view that as a substantial part of each tranche or both tranches, or would you view that as kind of typical for RFPs and signing contracts that some drop out? I just kind of want to get a flavor from the public staff as to whether the public staff views that as a significant termination amount or not.
There were 2 projects out of 10 in tranche 1. So, I mean, obviously there's always a risk that somebody's going to drop out. That's why you have the provisions in there. So not happy to see anybody drop out, but I don't know that I would call 2 out of 10 disturbing, but 5 out of 10 in tranche 2 is definitely, concerning.
And in your opinion, do you think, what do you think the future holds? Do you think this is something that will continue, or this was a one-time situation?
I would not want to speculate on that. I certainly hope it was a one-time situation, or it's going to be very difficult to meet our carbon plan goals if we're going to lose 50% of all of our winning bids going forward.
And have you discussed with the company or amongst yourselves of ways to have all of our winning bidders move forward?
Well, I think as Mr. Breitschwert indicated, we are having conversations with the company. I don't know that we've reached any definitive conclusions, or not as he said, as he asked me. And so that's something we'll be continuing to look at as we move forward. It is concerning.
Okay, thank you. And Commission, on that series of questions, Commissioner, questions?
No question.
Okay, thank you, Mr. McLaughlin, for your testimony today. We appreciate it. And you may step down, be excused. I'll take motions.
Commissioners, please.
This time, the public staff would move that the Exhibit 1 attached to Mr. McLaughlin's pre-filed testimony be entered into the record and marked for identification as pre-marked.
Okay, here, and Appendix A as well.
Yes, I keep forgetting that. Thank you.
Hearing no objection, the motion is allowed. Okay, would we want to move in the other public staff testimony at this point?
Yes, I would move that the pre-filed testimony be admitted into the record at the appropriate time. Oh, and are you referring to Mr. Cofield's pre-filed testimony?
Yes.
Commissioner Duffley, if it's helpful, I think both public staff witness Cofield as well as company witness Walker's pre-filed testimony exhibits were moved into the record by the commission's order issued.
The order?
Yes,
Okay.
ma'am.
Thank you for that, Mr.
Issued May
Breitschwert.
26th.
Okay, you may call your witnesses.
Thank you, Presiding Commissioner Duffley. The company calls witnesses Tabor and Holstein to the stand. And while they're approaching, just as a preliminary matter, we passed out summaries. We understand the commission's preference is not to read those, so we'll accept those into the record. One other logistical issue is when we pre-filed the company's rebuttal testimony, In the filing letter and in the testimony, we identified that rebuttal exhibits 1 and 4 contained confidential information and was filed under seal. There was one piece of confidential information in exhibit 2 that was also filed under seal. That was the guarantee agreement. So it was appropriately filed and redacted, but that wasn't appropriately reflected in the witness's testimony. So we're going to clean that up here at the outset and ask the commission to accept it as it was filed with the commission.
Okay, thank you for that. Okay, both swearing, left hand on the Bible, raise your right hand. Do you swear that the testimony you're about to give today shall be the truth, the whole truth, and nothing but the truth? So help you God.
Yes.
So before moving the witness's testimony in, if we could move the company's application in as into the record, please.
Yes, the application of DEC for approval of the CPRE Cost Recovery Rider and the 2022 CPRE Compliance Report pursuant to North Carolina General Statute Section 62-110.a and Commission Rule R8-71 filed on February 28th, 2023, consisting of 17 pages, will be admitted into evidence.
Thank you. And if it acceptable to the commission, we'll ask Ms. Tabor to move her direct and supplemental testimony into the record, and then ask Mr. Holstein to move the joint rebuttal testimony into the record.
Without objection, that motion is allowed.
Thank you. Good morning, Ms. Tabor. How are you?
Good afternoon, Mr.
Or excuse me, good afternoon. It's been a day. Been afternoon for a while. All right. Would you please state your name and business address for the record?
My name is Angela M. Tabor, and I am located at 410 South Wilmington Street in Raleigh, North Carolina.
And by whom are you employed in what capacity?
I am a renewable compliance manager for Duke Energy Carolinas within the Business Development and Compliance Department.
Thank you. And did you cause to be pre-filed in this docket on February 28th, 12 pages of direct testimony and one exhibit, which was the company's 2022 CPRE compliance report?
Yes.
And your exhibit contained confidential information?
Yes.
And do you have any changes or corrections to your direct testimony today?
No.
All right. Turning to your supplemental testimony, did you cause to be pre-filed in this docket on May 3rd, 2023, 7 pages of supplemental direct testimony?
Yes.
And that supplemental direct testimony contained confidential information?
Yes.
And do you have any changes or corrections to your supplemental direct testimony today?
No.
And if I were to ask you those same questions that appear in your direct and your supplemental direct testimony today, would your answers be the same?
Yes, they would.
And you've prepared a summary of your direct and supplemental testimonies together for the commission?
Yes.
Thank you. And Commissioner Duffley, at this time, I'd move Ms. Tabor's pre-filed direct and supplemental testimony into the record, as well as her summary as if given orally from the stand. I would also move Ms. Tabor's direct exhibit 1 be marked for identification as pre-filed, maintaining confidential information under seal, and then at the appropriate time accepted into the record.
Okay, so the direct confidential testimony of Angela Tabor containing, that does contain confidential information that was filed on February 28th, 2023, consisting of 17 pages, will be copied into the record as if given orally from the stand. Exhibit 1 will be marked for identification as it was when pre-filed. The supplemental testimony of Angela M. Tabor containing confidential information filed on May 3rd, 2023, consisting of 7 pages, will be copied into the record as if given orally from the stand. The summary will be copied into the record as if given orally from the stand.
Thank you. And Ms. Tabor, just before turning to Mr. Holstein, you jointly sponsored pre-filed rebuttal testimony with Mr. Holstein, and you're sponsoring that here today, and you don't have any changes or corrections beyond what Mr. Holstein plans to present. Is that correct?
Correct.
Thank you. All right. Mr. Holstein, now turning to you, sir, would you please state your name and business address for the record?
My name is Matthew Holstein. My business address is 525 South Tryon Street, in the 16th floor of the Duke Energy Plaza in Charlotte.
Thank you. And by whom are you employed and in what capacity?
I'm a finance manager responsible for the credit risk department at Duke Energy.
Thank you. And you, along with Ms. Tabor, caused to be pre-filed in the docket on May 18th of this year, 28 pages of joint rebuttal testimony, as well as 4 exhibits.
Yes.
And exhibits 1, 2, and 4 contain confidential information which was filed under seal.
Yes.
And do you have any changes or corrections to your joint rebuttal testimony today?
Yes, there are 2 corrections. First, on page 5, on lines 7 and 8, should be revised to identify that Exhibit 2 also contains confidential information. The sentence should now read, certain financial and project information in Rebuttal Panel Exhibit 1, Rebuttal Panel Exhibit 2, and Rebuttal Panel Exhibit 4 is confidential and is being filed with the Commission under seal. Second, on page 20, line 15, the word system should be deleted from the confidential portion of my testimony.
Thank you. So subject to these corrections, if I were to ask you the same questions that appear in your joint rebuttal testimony today, would your answers be the same?
Yes.
Thank you. And you prepared a summary of your joint rebuttal testimony for the commission?
Yes.
All right, thank you. And Commissioner Duffley, at this time, I'd move the joint rebuttal testimony of witnesses Tabor and Holstein be copied into the record as if given orally from the stand. I'd ask that the rebuttal panel exhibits 1 through 4 be marked for identification as pre-filed, including meaning all information pre-filed is confidential under seal in exhibits 1, 2, and 4, and then be accepted in the record at the appropriate time.
Okay, the joint rebuttal testimony of Angela M. Tabor and Matthew Holstein containing confidential information filed on May 18th, 2023, consisting of 28 pages, will be copied into the record as if given orally from the stand. The 4 exhibits will be marked for identification as they were when pre-filed, and will noted that exhibits 1, 2, and 4 contain confidential information.
Thank you. The panel is available for cross-examination and questions from the commission.
Any cross-examination?
Not from the public staff, but we would like to reserve the right to ask questions on commission questions.
Okay, Commissioner questions? Chair Mitchell.
Good afternoon. You all were in the room when I asked Mr. McLawhorn several questions related to the Wilk Solar situation. Is that correct? And did you hear his responses to those questions?
Yes.
Is there anything else you all, is there anything you all want to say at this point, either in response to questions I asked him or in response to information he provided in response to those questions?
I have something I'd like to say, yeah. So to the point of the guarantee expiration date being short, it's quite common for guarantors to provide expiration dates on an annual basis and frequently at the end of a fiscal year. So in this case, December 31st. So it's not at all uncommon for our credit risk department to see a guarantee expiring 14 months into the future on December 31st and see that as a red flag because that's something we see commonly. And it's frequently renewed on an annual basis by the guarantor. And contractually, that's what was required under this PPA.
Your testimony, and this is a confidential number, so I'm not trying to elicit any confidential information from you all, but your testimony indicates that it's common for security instruments to contain no expiration date, no set term, I guess, just sort of be of indefinite term. Is there any reason going forward for purposes of future procurements that the company may conduct to, is there any reason not to require that performance assurance that's provided contain no expiration date?
I think we would run into difficulties with some of the developers in agreeing to something like that. Although it is common to have no expiration date on guarantees, there are a number of entities that are very uncomfortable with that concept and would thus not be willing to do so.
And I just want to add one thing to what Witness Holstein said there. Parent guarantees are a form of security that we do allow. It's not the only form. And in CPRE, we had other projects that also had parent guarantees. We are looking at the use of, tools and continuous improvement, and we'll talk about that. That's in our testimony as well. But there are parent guarantees, and they do have different terms.
Okay. believe it is in your testimony. Let me get there. While I'm looking for my notes, can you all respond to the question that's been asked regarding Wilk Solar's participation in future procurements that the company might conduct? What's the company's position there?
At this time, the company is still evaluating what the right approach is, but we do work with stakeholders and with public staff, and we are in that process for the 2023 solar procurement currently. We're at a point where we've gotten some comments and feedback on the documents that have been posted to the 2023 RFP's website, and we'll be addressing those and continuing to work with stakeholders. Tentatively, we have the next stakeholder session scheduled for mid-June.
Okay. So your testimony it's the rebuttal testimony, page 9, looking at lines 13 through 20. Just let me know when y'all get there. Okay. You make the point that IPP counterparties can provide substantial value to customers through outsourcing development and creating low-cost purchase power options, I'm sorry. Did I read that testimony correctly?
Yes.
Okay. After I corrected myself. We've talked there's been testimony today regarding the number of market participants or bidders that have withdrawn from the CPRE tranches. And I think your testimony indicates that there were 3 Tranche 2 projects that have terminated their PPAs and 2 CPRE Tranche 1 projects that failed to achieve the COD set forth in the contract. Is that correct?
I want to make one comment on that. For CPRE for Tranche 1, we've had one project that has terminated and paid the LDs. And we have one project that we're continuing to have discussions with. I think we've preliminarily signaled that we expected them to terminate because we know there are challenges, but we are continuing to have commercial discussions with that project to find a path forward.
Okay, so and that actually I was going to ask you about that. So I'm glad you provided that additional information. So of those 2 from Tranche 1, one has terminated and one it remains a possibility.
That's correct.
Okay, well that's okay. Good news. So again, just back to your testimony that IPP counterparties can provide substantial value to customers by creating low-cost purchase power options and sort of keeping in mind the avoided cost threshold that was set in this CPRE paradigm and sort of looking ahead. What are we going to do to ensure that there are actually the IPP capacity that we are planning for materializing and actually materializes, and it materializes at lowest cost?
So we continue to hold competitive procurements. And so in the competitive procurement process, we are evaluating the projects on economic and non-economic factors. And we, for 2022, have made offers to the projects that were selected. And we looked at the amount for the LDs as we were coming up with any changes to the PPAs between CPRE to 2022 to 2023. And we continue to evaluate those. The LDs are actually a little higher when we get to the solar procurement for 22 and 23 because the term is longer and it is based on the production of the facility over the life of the facility. So going from a 20-year term to a 25-year term, there is an increase in the LDs for a project that would otherwise be the same size.
I know that we are still, thank you for your testimony. I'm going to ask you one question that sort of strays from the matters at hand, but we're early in the 2022 procurement process, but any signs of trouble with respect to the winning bidders?
No.
Okay, I think that's everything for me.
Commissioner Claufelter.
Good afternoon. I'm not sure which one of you should answer, so whoever wants to take the question can take the question. On your rebuttal testimony, page 12, if you can get that in front of you. And I'm looking at the answer you provide on lines 16 through 18. And the testimony says there that the credit risk department will engage Duke Energy's legal department if the counterparty or its lending institution seeks edits to the standard forms. My question about that statement is when a counterparty, in this case a guarantor, in this particular case, proposes a defined expiration date for the guarantee that is sooner than the expected commercial operation date, does that trigger a review by Duke Legal?
No, that would not be something that necessarily would trigger Duke Legal review. It's usually more of a change to the provisions or the insertion of a new clause in the guarantee that might have legal review required.
So that is not considered an edit to the standard form?
The standard form allows for an expiration date if it should be in there, and it does not state whether or not COD is a condition for whether or not it would be considered standard.
Okay, so does the credit risk department, when presented with a request for a defined expiration date, consult with anyone else about how that date stands relative to the expected commercial operation date?
It depends. So we'd usually be involved in having discussions with whatever business unit the guarantee was covering a contract in relation to. If we had a reason to be concerned, it would come up. In this case, that wasn't one where we felt like we had a reason to be concerned.
You anticipated my next question, so the question was going to be, did that occur in this case?
We did not have any discussions with legal about the guarantee expiration date.
Well, what about with the business unit that was overseeing the procurement process?
If we had any, I may ask Ms. Tabor to weigh in here, but my department does not have any email histories that states that we had a back and forth with them about that expiration date.
Who would have that, if there were any?
Based on the date in which this guarantee was put in place, it's most likely that our retention policy does not have it any longer. So unless Ms. Tabor's organization has the email history, it's not clear.
If you were asked to make a search to see if there was any discussion with the business unit about whether this was an acceptable date relative to the expected commercial operation date, could someone make such a search and at least say we have something or we don't have something? Could that be done?
We could ask the question to Ms. Tabor's group, and I don't know how you would want to respond, but I can respond based on your response here.
Commissioner Claufelter, I would say that we looked and were not able to come across any specific correspondence to answer that question.
You've already done the search and the answer came back negative. You're off the hook for that question, because we're going to go to page 14 of your rebuttal testimony next. And I'm going to ask you about some information that you put in here in confidential, but I'm going to ask the question in a way that I don't want an answer that goes into confidential information, but I want to refer you to the question on line 13 and the answers on lines 14 through 16. And you provide some information there about the number of security instruments that you've managed that do not have a defined expiration date. And through the process of arithmetic, I can calculate a number of those that do have a defined expiration date. So understanding that letters of credit by law must have an expiration date. So I've set those aside in one category. They have to have an expiration date. The law says they must. So of the difference between the two numbers you do provide there in the confidential testimony, if you were asked to do so, could you provide a breakdown of those that constitute either cash deposit? Well, cash deposits would not have an expiration date. I don't know how many of those you even have. Do you get cash deposits?
We do get cash deposits.
For the PPA performance assurances? Not for proposal security, but for PPA performance?
I don't believe we're holding any related to the CPRE process.
Okay. Well, let's leave cash aside. It's just, but for guarantees and surety bonds, if you were asked to do so, could you provide a breakdown of the difference there as to those that guarantees and surety bonds that do have a defined expiration date?
Yeah, on the stand today, no, but we do have that information available to us that we could provide.
Okay, I think I would like to see that in a late file exhibit. And if we could give a categorization by expiration date of less than a year or less and expiration date of more than a year.
All right,
Okay.
thank you.
And again, I'm not interested in letters of credit because I know those have to have expiration dates. So that's all I have.
Guarantees only
Guarantees and surety bonds.
and surety bonds. Thank you.
Thank you.
Commissioner Hughes. Commissioner McKissick.
Just one or two questions. And it goes back to some of the questions asked of Mr. McLaughlin. Of course, the power purchase agreement in this particular instance with Wilkes was executed on or about October 15th of 2020. Is that correct?
Yes, and that's actually an exhibit to the
Yeah.
testimony.
Yeah, I think you will have it as an exhibit to the exhibit 1 as a part of your joint rebuttal testimony.
Yeah.
And of course, it does have exhibit 6 attached, which is kind of a standard form guarantee. And it does not contain any type of termination date or anything like that on that particular exhibit. Is that correct?
So if you're looking at the template guarantee form as part of the
Yeah.
PPA, it contains a location for where one could be input, but not an actual date in the template form.
So there was
itself.
no data attached to that particular
Correct.
one. And in looking at the actual guarantee that came in, it came in on the 21st of October. Is that correct?
I believe so.
And it did in fact have an expiration date, which would have been that December 31st of 21.
Yes.
Now, I believe there was some discussion earlier about section 5.1 dealing with pre-COD.
Yes.
Now, that does provide for a submission of, say, performance assurance within 5 days. Is that correct?
Correct.
But when that guarantee came in, that would have been outside of the 5 days, wouldn't it?
The section 5.1 references 5 business days. I don't have the calendar in front of me, but it seems reasonable that that could have been within 5 business days.
Okay. Now, let me ask you this. When it came in, I guess what I'm understanding you to say, the fact that it would have expired in about 14 and a half months would not have been a concern to you?
Correct. Yeah, that's fairly common. We do get a lot of companies that have policies against providing expirations beyond the end of their next fiscal year or beyond a certain date into the future. So we do get guarantees that often expire on December 31st, and it covers a term that's longer than the guarantee's expiration date, in which case they usually reach out to us and provide updated security for the next year.
Now, would there not have been a good business practice to at least have established a guarantee period that would have likely at least coincided or reasonably coincided with the projected operations date of the facility?
I don't disagree with you that would have been an ideal situation, or even the ideal expiration would have been the end of the PPA term 20 plus years into the future. However, it is actually fairly uncommon to get a guarantee that expires 20 years into the future. And then, like I said, it's not very uncommon for a company or a guarantor to issue a guarantee that expires at the end of their next fiscal year from the time at which it was sent to us.
Now, in the contract, there's a section that deals with events of default. Is that correct?
Yes, I believe so.
And if you look under section 19.18, I'll give you a second to get there. Are you there?
I am there.
Under 19.18, it says seller fails to provide, replenish, renew, or replace the performance assurance and or otherwise fails to fully comply with the credit-related requirements of this agreement, including without limitation, section 5, and any such failure is not cured within 5 business days. Did you consider the expiration of this performance instrument, the guarantee agreement, as an event that would have triggered a default?
Yes, under the contract, the guarantee expiring is an event of default.
And did you take any actions as a result of that to enforce the terms of the agreement in terms of the remedies that could have been pursued in terms of the event of default as defined in the terms of the agreement?
At the time the guarantee expired, we were not aware due to the omission in our system. So we didn't become aware of the guarantee's expiration until July of 2022, at which case the guarantee had already expired. And as far as enforcing our LDs under the agreement, we have had discussions with Wilk Solar about those LDs. And I don't know, Ms. Tabor, if you have anything else you want to add to that, but I would say we have attempted to collect on those LDs despite the expiration of the guarantee.
And as I gather, you've been unsuccessful.
That's correct. But I will note, Commissioner McKissick, that in our letter of default for the PPA that was sent out in August, we did reserve our rights and remedies under the PPA. And so there's still time. We're under evaluation, and there's still time for us to further pursue. Just thus far, these are the actions that we've taken.
And in that letter that you referred to, it seems like you also identified several reasons that would not have constituted a basis for them not proceeding with this agreement. Is that correct?
Let me look at the
Sure.
letter.
I need to find it myself. I'm just going by my recollections. And one letter I'm looking at here now is one dated July 5th of 22. And it says the obligations to construct a facility is solely the responsibility of Wilkes. Nothing in the agreement provides Wilkes obligations to construct, own, or operate the facility are contingent on the results of a system impact study, the availability or unavailability of tax credits, or the overall cost to Wilkes to construct a facility, and none of the items listed in your email would constitute a permitted excuse to perform under the terms of the agreement. You see that language?
Are you in the first paragraph on the July?
Yeah,
5th
first
letter?
paragraph under the July 5th letter. I think that's when I was thinking about when you started referring to a letter. Even though I think there was another one here as well.
Yeah, that's the one that I was referring to, Exhibit 4.
Okay,
Exhibit 3 was one of the letters
okay,
when we were trying to work through mutual termination of the PPA with the counterparty. Exhibit 4
okay.
is actually
The one, I see that
letter
one there
that
as well.
terminated, notice of termination and default of the PPA.
Yes, I see that one as well. Now, let me ask you this. In that earlier letter, I guess on July 5th, you identify a number of reasons that would not be a permitted excuse to perform. Are those reasons that Wilkes had referred to in communications with Duke as a result, in terms of stating why they were not proceeding? Because they are specifically identified. That's why I raised that question.
Yes, they had brought up issues and delays in interconnection. And if we go back to the testimony, I walk through the steps and how the interconnection process works and how things were going between Wilkes and Duke Energy in the interconnection process. And we were treating Wilkes Solar as we were treating other projects that were going through the interconnection process. It takes time to receive your study results, to get an interconnection agreement, to come to terms on the interconnection agreement. Duke offered in April 2022 an interconnection agreement to Wilkes Solar, and they declined to sign that interconnection agreement. And they were stating that there were delays caused by Duke that then made their project not a viable project. And so I think those are those permitted excuses to perform that are then referenced in this July 5th, 2022 letter.
Now, would it be Duke's contention that there were no delays, or were there delays that you would call excusable delays?
There were delays that Duke and the development community were aware of, which are part of the reasons that Duke moved away from a serial interconnection queue to a cluster study model. And so there was nothing that happened between Duke Energy and Wilkes any different than the other customers that were going through the interconnection queue. And so that is why, where it says permitted excuse to perform, again, there was no different treatment between Wilkes Solar and other solar developers that were moving through the serial queue.
So all other similar situated parties were experiencing similar delays, and there was nothing unique about Wilkes' circumstances.
That's correct.
How long were the delays? If you know.
My role in compliance and managing, the CPRE program, there are pieces that I'm aware of, but there's certainly pieces that are outside of the scope of my responsibilities, and probably better to have someone else answer that specific question.
Very good. And let me ask you this, have there been other solar projects, similarly situated where there were guarantee agreements signed, where there had been a default and you made demand for liquidated damages?
There were 3 other projects in Tranche 2 that had parent guarantees as their security instrument. And those projects elected to terminate the PPA and move forward with payment of the liquidated damages that were owed under the PPA. And I don't know, Mr. Holstein, is there anything else you want to add there related to parent guarantees?
No, I think that's an accurate description of the guarantees associated with the CPRE process. There were 3 that we were able to collect on.
Were any of those guarantee agreements expired?
No.
Thank you. I don't have any further questions.
Commissioner Kimmerite?
Yes, just to follow up on the questions about Wilkes Solar's allegation that interconnection delays were the reason that it terminated the PPA. And I think this is on pages 16 and 17 of your rebuttal testimony. I think if you provide testimony to McKissick that there was no delays for Wilkes Solar that were in excess of other projects in Tranche 2 of CPRE. Is that right? But the delays were not more excessive for
Correct.
Wilkes Solar compared to other projects in Tranche 2.
Correct.
And then I saw on page 15 of your rebuttal testimony that Wilkes Solar was actually studied through the transitional serial process. Do you know whether other projects in Tranche 2 were studied in the cluster process as well? Or do you have that information about which processes at that time Tranche 2 projects were studied?
I don't have the specific breakout, but I did look at the projects in Tranche 2 and the timing of their interconnection agreements. And there were other projects that did not get an interconnection agreement until Q1 of 2022. So there were some that did have to go through the transitional serial process. And the delineation point for projects to go and stay in serial versus to move into transition serial was the August 19th date when we transitioned for Q reform. And so they did have their facility study agreement, which allowed them that choice of transition serial or transitional cluster at that moment in time.
And for a project that, my understanding is a project that would be studied under the transitional serial process, would be studied. Sorry, for a project that would be studied under the transitional serial process would be studied in advance of projects that would be in the transitional cluster or the cluster process. Is that correct? So Wilkes Solar potentially would have been studied in advance of
any other project in the transitional cluster or the cluster process.
That's correct.
Okay, thank you.
Commissioner Klopfelter?
Sorry, folks. Come back to something. If you had caught the expiration of the guarantee, if it had been logged in and it had popped up and you saw it was coming up, you would have insisted, am I correct, that it be renewed, or else you wouldn't have proceeded?
Right, so we have a report that, it's called the 90-day report, which tells us any piece of security that's within 90 days of its expiration date. At that point, we're not worried when it's at 90 days, but once we get inside 30 days, we're usually reaching out proactively to try to get something renewed.
And if you don't get it renewed, you stop.
Right.
You come to
we
a
take
halt.
Whatever legal, yeah, whatever actions we would explore whatever actions. we
You don't do anything else on the project till you get
Most
that,
likely.
till you get that issue cleared up.
Yep.
So if you were asked to do so, could you accumulate your costs incurred after the expiration date of this guarantee in connection with preparing and tendering and negotiating the interconnection agreement and further work on this project? If you were asked to do so, could you provide that data? What did you incur after the expiration of the guarantee?
I don't know that I'm the right person to answer that question.
Well, those costs are collected and accumulated internally somewhere because they're ultimately charged back to the
Commissioner
project.
Carter, can I ask for a clarifying?
Sure.
So under interconnection and interconnection costs, those are separate from the power purchase agreement. And the
Correct.
power purchase agreement
Correct.
cost.
Correct.
So this guarantee is meant to cover the power purchase agreement, and there's a letter of credit or different instrument under interconnection.
I understand.
Okay.
My question is, what internal costs did you incur after the date or expiration of this guarantee in connection with this project?
I don't know that we can definitively say that there are direct costs that we incurred as a result of this project. As far as the calculation indirect costs, like I said, I'm not the right person to answer that question. I don't know if Ms. Tabor is either.
I'm not the right person to answer the question. I think
I won't ask you to answer a question you're not the right person to answer. All right, I'll think about that one. One last thing though, it occurred to me as I was thinking about the question I just asked you, that the expiration of this guarantee actually says that the passage of the date certain does not extend to any outstanding obligations that had been incurred prior to that point. In other words, those continue to be guaranteed even after the date certain. Were there any unpaid milestone payments, progress payments, study payments, facility study agreement payments, anything else that was due to you that is still due to you and uncollected as of the date of the expiration of the guarantee?
I'm not aware of any uncollected payments to us outside of liquidated damages, whether it be before or after the guarantee.
Yeah, leaving aside liquidated damages, I understand that's the issue, that's the big one. But the Guarantee Act specifically says that if there's anything outstanding and due as of the date of the expiration, that's still covered by the guarantee. And I just want to be sure all that had been cleaned up and has been collected.
Yes, I'm not aware of any outstanding dues to us prior to the expiration.
Thank you. I promise not to come up a third time.
Chair Mitchell.
I just want to make sure I understand your testimony in response to Commissioner Kimwright correctly. So Wilk Solar was in the transitional cluster study, is that correct?
they were in the transitional serial study, which preceded the transition cluster study.
Okay, so subsequent to making it through the transitional serial study, being tendered the interconnection agreement, which Wilk Solar did not sign, has Wilk Solar made another interconnection request of the company?
No.
Okay, thank you.
Commissioner McKissick.
Just one quick question, without getting into any of the numbers in this case. What methodology is used to determine the amount of liquidated damages that are appropriate for specific power purchase agreement? How do you go about establishing that number and that amount?
So the liquidated damages is a calculated amount based on the production of the facility over the life of the term. So for the CPRE projects, it's a 20-year term and it's a 4% production over that 20-year term to calculate the amount for liquidated damages. And it's included when the PPA is offered to the counterparty for signature as part of the exhibits.
So that's a consistent methodology that's used with all of your
Yes, it
power
is.
purchase agreements. Thank you. I was just curious. I hadn't seen that explanation.
And to follow up with that, the pre-commercial operation date, liquidated damages, how is that amount calculated?
Commissioner Duffy, can you point me to where you're looking at that?
I saw the list, right? The production list of liquidated damages. So is it the same methodology?
It's the same methodology for, well, let me turn to the PPA and the language in the PPA.
Let me know where you are when you get there.
Commissioner Duffy, are you looking at in section 5.2, page 13 of the PPA?
Yes.
Okay.
Okay, that will explain it right there. So did you hear how public staff described what the liquidated damages were to be used for? And do you agree with the public staff's testimony on that issue?
Can you point me to the,
So he stated, when I asked public staff on the stand what public staff feels is the purpose of liquidated damages, and he responded, it is for replacement power, the higher cost to have to replace the power and the capacity. And do you agree with that statement? And is there anything you'd like to add to that?
let me look at a response that we provided on liquidated damages. I thought I had a different note here, but it's probably in my testimony. Give me just a moment. I'm sorry.
Take your time.
Ms. Tabor, in the interest of time, page 10 may be a good place to start your review.
So in the rebuttal testimony on page 10, we explained that LDs are used in these complex commercial purchase transactions, such as the CPRE program, to compensate the non-defaulting purchaser of power for accepting the complex risk of incurring potential costs resulting from a PPA seller's failure to meet delivery obligations and/or termination of the PPA. They're generally used to compensate the company and its customers for the cost of replacement for the contracted resources. It's difficult to determine the replacement cost at the time of the contracting LDs, and so they're used as a proxy. And so, they're meant to be something that at the time of contract signature, you can agree to with the counterparty. But as I state here, it's difficult to determine exactly what that cost of replacement power is going to be. One of the pieces that has come up that I think it's worth noting is avoided cost. And in the context of future procurements and avoided cost for the 2022 solar procurement, we are able to say that the 25-year avoided cost rate, the projects, many of them have come in under avoided cost, just as a piece of information.
Thank you for that. So let's assume hypothetically that the guarantee had not expired. How often does a guarantor not pay liquidated damages in a similarly situated situation to this, assuming that the guarantee had not expired?
Fortunately, we don't have a lot to pull from as far as renewals procurement counterparties who have defaulted and provided a guarantee. And the most recent tranche, we had the 3 counterparties who did, and we were successful in collecting on all 3. So that's really all we can point to at this point.
Okay, but can you broaden that out to non-third party counterparties? Just in general, your work in the credit risk department, what percentage of guarantors don't pay liquidated damages if it had not expired?
I don't want to speculate too much here just because, so I've been in the credit risk department now at Duke for about 5.5 years now, and we have, I'm not aware, we've definitely gone to court a couple times over guarantees that we've tried to collect on. And I know we've won in some cases across the enterprise. So I am aware there have been cases where we have been fought on a valid guarantee. There are plenty of other cases where we have not been fought and LDs are just paid. So I don't want to speculate and give an actual percentage because I don't feel comfortable giving an accurate one here. But I know we've seen both outcomes.
Okay, thank you for that. And then if you could turn to Exhibit 3, where in, I don't have it pulled up in front of me, but DEC mentions a termination agreement by mutual agreement. And my question, I probably missed it in reading through the papers, but are the liquidated damages less if you terminate via mutual agreement? Is there some provisions like the extension for the commercial operation date? There's a smaller number for liquidated damages. I'm just wondering what the import is of terminating not by default, but by mutual agreement.
Well, part of mutual agreement is the payment of the LDs that are owed under the contract. So when we offered them the mutual termination agreement and they returned it to us and struck out the LDs, we weren't able to actually reach a mutual termination agreement with the counterparty.
Okay, thank you. And did you hear my question to public staff about, do you have any thoughts or recommendations with respect to what, if anything, the commission should do with respect to Wilk Solar's CPCN?
We did hear the question.
Yeah, I did hear the question. I'm not sure I do not have a recommendation.
Okay, fair. And then I have these staff questions. Thank you for the clarification about tranche 1. I think it would be helpful. I asked public staff to prepare a late filed exhibit regarding everything that's happened within CPRE, basically, and what contracts do you have signed, who dropped out, so we have the full numbers of what you can give to the commission. And if you'll work with public staff and the two of you file a joint filing that together so that we have the most accurate information on that late filed exhibit that I requested or the commission requested. And then can you tell us Do you have anything else to add? I know you've been asked and we've heard lots of questions about the reasons underlying PPA terminations. Do either of you have any additional information regarding the underlying reasons for these terminations?
So for CPRE tranche 1 to tranche 2 to where we are today, I think that we have seen the market and feedback that we've received from the market is that with COVID and the supply chain challenges and the ability to get solar panels for the cost that you initially thought you might be able to get solar panels for, there just have been many market conditions that have shifted over time. And when you look at the timing specifically for CPRE tranche 2, those bids came in March of 2020 before we all even knew what was coming with COVID. And so I would say that that is a big driver of what we have seen happen specifically with tranche 2. And further, we don't anticipate that to just continue and to continue to have cascading failures of projects. We're committed to moving forward and working towards the goals of the carbon plan. And we had a robust response to our 2022 solar procurement, and we hope to continue to have robust responses to the procurements moving forward.
Okay, thank you. And are there any other additional anticipated PPA terminations that the commission's not aware of?
I don't think there's anything you guys aren't aware of. We're still working through the tranche 1 project.
Okay, thank you. And so on page 12 of your rebuttal testimony, going back to that section 5.7. So I've heard testimony that the seller's failure to maintain or replace the performance assurances is a default under the PPA. So what penalty or remedy is provided for this specific event? And is it any different than the later default? Potential default, I should say.
Don't think it's any different. As it says, we shall be entitled to draw and retain the full amount of the performance assurance, which that's basically the LDs themselves. But I will note that with the termination letter that we sent in August of 22, we did retain all of our rights and remedies under the PPA. So there are more discussions that can be had at Duke with management about steps. We still have time to do that. So.
Okay, thank you for that. Do you have anything to add?
No, I just to kind of add to what Ms. Tabor was saying is, she mentioned there are steps that we can take. There is a dispute resolution process that we could potentially be going through with Wilkes Solar or Wilkes Solar's owners.
But you haven't availed yourself of that avenue of relief at this time, correct? The dispute resolution or arbitration?
Yeah, we have not gone fully through that process with them. And we have not yet. We still retain the right to do so.
Okay, thank you. On page 24 of your rebuttal testimony, you state that the company has determined that the guarantee has expired and DEC likely would not be able to recover from DESRI for reasons that have nothing to do with whether Wilkes Solar is liable for the payment of liquidated damages under the terms of the PPA. Could you please elaborate on the reasons underlying the company's determination that it will be unable to recover from DESRI? Is it, and I guess as a follow-up to that question, is it also related to the amount to pursue it could potentially equal the liquidated damages?
I won't touch on exactly how much it could potentially cost to pursue it, but the reasons why we have come to the conclusion that it may be difficult or imprudent to go after Wilk Solar, that these special purpose entities are often set up with no real assets behind them until they begin or have a constructed asset on the ground. So we think it's unlikely, not necessarily impossible, but unlikely that Wilk Solar has any real support behind it. So even if we won a judgment against them, we may not be able to collect much. And without the guarantee in place, we wouldn't have, we've been advised that it may be difficult to enforce our claims against DESRI portfolios or DE Shaw Renewables in this case.
Okay, thank you. And then if we could request a copy of Greg Slovik's June 10th, 2022 email. I guess it was to Scott Tharp as a late filed exhibit. And then are there other written communications between Duke and its representatives and Wilk Solar and or DESRI or their representatives?
Commissioner Duffy, can you repeat the question one more time, please?
Sure. So in your exhibits, like Exhibit 3 and Exhibit 4, there were exchange letters or emails that were being exchanged between the company and Wilk Solar. And so the question is, are there other written communications regarding this default or liquidated damages? Are there other written communications between the company and Wilkes, as well as are there other written communications between the company and DESRI or Wilkes or DESRI's representatives?
We can certainly go back and look for additional, these were the most pertinent letters we felt like it was worth sharing, but we can certainly go back and look at other communications if that's an action that we need to take.
Yes, if you could provide any other pertinent communications as a late filed exhibit.
And Commissioner Duffy, just point of clarification, to the extent they're substantive or material, that's what you're looking for, not any.
Correct.
Okay.
Correct.
Thanks.
And so, and then the next question is, does Duke Energy or any of its affiliates have any other transactions with Wilkes Solar or the DESRI portfolios or affiliates?
I think some of the answers to that question could potentially be confidential.
Okay. Okay, well, this is staff question, so I want to be sure to help my former fellow staff member.
Commissioner Duffy,
So,
to the
yes.
extent it's helpful, we could supplement the late filed exhibit you requested with answering that question in writing.
Yes, that would be good, and file it as confidential. And then if you'll also answer this next question, if yes, are there actions being taken as a result of the default issue? Okay, any other questions, follow-up questions? So one last follow-up is with respect to DEP. We've seen the withdrawals and terminations in the DEC area and not in the DEP area. Is there any explanation for that?
I think a large part of it is just the limited number of CPRE projects that were selected for DEP. We only had a couple in tranche 1, and those are both online and operating, and we have one for tranche 2. I think that they've experienced some delays that we'll continue to share with you guys. But there's only 3 projects versus, many more projects in DEC, so much more just exposure and risk.
Okay, thank you. Anything to add?
No.
Okay, thank you. Any other follow-up? Okay, commission on, questions on commission's questions.
Just a couple, Commissioner Duffley. Good afternoon, Mrs. Tabor and Mr. Holstein. I don't think we've met. My name's Tom Felling. I'm an attorney with the legal division in the public staff. I'll try to be brief here today, and I think my questions are for you, Mr. Holstein, but Mrs. Tabor, if you have a response, feel free to please chime in. There was, I think, the initial question from Chair Mitchell, and I think there were follow-up questions as well, so this might go to multiple questions, but you were, Mr. Holstein, you were asked to respond to any of the questions that were posed to Mr. McLawhorn, and you gave a response in that kind of general question that something to the effect that it was common for guarantors to provide guarantees with annual expiration dates or something to that effect. Do you recall that answer? And is that negotiation date in a performance guarantee, and in this particular case, the parent guarantee, those are negotiable. Is that correct?
Yes, they can be. Well, it depends on what the underlying agreement is, but it certainly can be negotiable.
Okay. And so if Duke had wanted to, or if it wanted to push back on that 14-month expiration, that's certainly a term that Duke could have negotiated for a longer expiration. Is that correct?
Potentially.
Okay. And if a longer expiration date was not going to be an option from DESRI, it's possible that Duke could have sought another form of a performance insurance. Is that correct?
Correct.
Okay. And no further questions.
Questions?
Just a few. So, Mr. Holstein, Mr. McKissick, or Commissioner McKissick asked you a number of questions about section 19.18 and the default provisions of the PPA. Do you recall those questions? And I don't think you need to refer to it.
Yes.
Okay. And you explained that's routine for parent guarantees to extend only to the end of the counterparty's next fiscal year. That's standard business practice in your industry.
Yes, that is common.
And referring to the terms of the PPA in general, while you're not an attorney, you are responsible for managing the credit risk department for Duke Energy. Is that correct?
Yes.
And based on your expertise and responsibility managing the credit risk department, is it your understanding that the intent of this section providing for performance assurance, as well as section 5.1 that I discussed with witness McLawhorn earlier, to mean that only the, as I'll put in quotes, the ideal performance assurance extending to the full 20-year term is acceptable? Or could a shorter term that's renewed during the term of the contract also be acceptable under the term of the company's purchase power
I
agreement?
believe that could be acceptable, and that this particular clause in the agreement points to that.
And that's how the company's implemented the agreement?
Correct.
Thank you. I think, Ms. Tabor, this is for you. Commissioner McKissick also asked some questions about Exhibit 3, which is the July 5th letter from the company to Wilkes Solar. You recall that?
Yeah.
And so reviewing that letter, one of the things that we didn't touch on in that discussion was the statement by Wilkes Solar about the unavailability of tax credits. You recall that?
Yeah.
Is it your recollection that one of the arguments that Wilkes Solar brought forward was the delays, the alleged delays in the interconnection process had impacted their ability to obtain tax credits to fund the project? Or
Yes, that's my understanding of one of the issues.
and is it fair to say in developing the RFP that that was the responsibility of the bidder to evaluate the assumptions on which they would be able to finance and develop the project?
Yes.
And as you said in that letter, that's no basis for the counterparty to elect not to move forward under that purchase power agreement.
That's correct.
Thank you. Commissioner Clodfelter asked a few questions about the interconnection costs that could have occurred. I think we refer to it as post-default under the terms of the agreement. So after December 31st of 2021, when the performance guarantee expired. Do you recall those questions?
I do.
And it's fair to say, just based on your general understanding of the interconnection process, that there was some administrative work that the company undertook to complete the facility study, presumably hold a customer options meeting in advance of issuing the interconnection agreement, and then issuing the interconnection agreement during those ballpark 4 months in early 2022. Is that fair?
Yes, that's correct.
And so there would have been some administrative costs that the company presumably incurred that could be developed if that was of interest to the commission to identify what those costs incurred were under the interconnection process.
That's correct. I believe we would need to consult with the interconnection team to get details, but I also believe that a final accounting report has been completed for this project.
Okay. And to be clear, under the power purchase agreement, the company's not incurred any PPA related costs. There's not been any dollars from Duke and customers to Wilk Solar. And there's not any Wilk Solar related cost in this revenue requirement in this case. Is that accurate?
Yes, that's correct. There are no costs directly tied to the PPA.
Okay. And in fact, there were under the interconnection process, there was separate security that was required by Wilk Solar to be provided to the company that the company was able to exercise upon. Is that accurate?
Yes, that's correct.
And that was a letter of credit.
That was, as far as I understand, the letter of credit.
Yeah.
Okay. And do you recall how much that was?
800,000.
Okay. So you were able to provide to, for the benefit of customers, $800,000 resulting from Wilk Solar's default in the interconnection process, separate and apart from the PPA pursuant to the terms of the North Carolina interconnection procedures.
That is correct.
Okay, thank you. That's all I have. Thank you.
Okay, thank you for your testimony. Mr. Clark.
Mr. Barshwart, I thank you for collecting the information I was trying to get. I want to be sure I understand it. Did you draw the 800,000 LC to cover your admin costs post expiration?
The $800,000 letter of credit was drawn to cover whatever admin or other related costs would have incurred underneath the interconnection agreement.
So what I was asking about really was those admin costs that you incurred. I understand you didn't execute an interconnection agreement, but the admin costs, and you covered those admin costs by a draw on the LC.
Correct, yes.
Got it.
No, thank you. Thank you. Commissioner Duffley, at this time, we'd ask the company's application and exhibits be entered into the record to the extent that's not already been done.
To the extent that it's
Thank you very much. The exhibits as well, please.
orders and legal briefs. The commission legal team was by legal briefing from the parties and to answer these questions. So is brief whether there's a commission decision to impose a penalty on to from staff's recommendation Duke was involved in Wilk Solar all that. Whether the second question is whether Wilk Solar's default or fault for the default is a condition precedent to imposing a penalty on Duke for failing to not note the expiration of the guarantee. Also, is there precedent or remedy provided in the CPRE PPA in the event that Wilk Solar's termination was the result of undue delay on Duke's part? You could prepare a legal brief on those questions and then proposed orders as well as these legal briefs 30 days from service of the transcript. Does that meet everyone's agreement? Very good. Thank you. And we'll be adjourned. We'll take an afternoon break. How many minutes? 10 minutes. So we'll be back on the record at 4:40.
Record. I am Karen Kimmerite of the North Carolina Utilities Commission, and with me this afternoon are Chair Mitchell, Commissioners Brown Bland, Clodfelter, Duffley, McKissick, and Hughes. I now call for hearing docket number E7, sub 1282, in the matter of application of Duke Energy Carolinas LLC pursuant to North Carolina General Statute Section 62-133.2 and Commission Rule R8-55 relating to fuel and fuel-related charge adjustments for electric utilities. North Carolina General Statute 62-133.2 provides for annual fuel charge adjustment proceedings for electric utilities engaged in the generation or production of electricity by fossil or nuclear fuels. Commission Rule R855 provides that the fuel charge adjustment proceeding for Duke Energy Carolinas LLC, that I'll refer to going forward as DEC, will be held the first Tuesday of June of each year, and that DEC shall file its direct testimony and exhibits and shall publish notice prior to the hearing. On February 28, 2023, DEC filed its application to adjust the fuel and fuel-related cost component of its electric rates along with the direct testimony and exhibits of witnesses Signori Clark, Jeffrey Flanagan, John Swez, David Johnson, Kevin Houston, and Stephen D. Capps. On March 1, 2023, DEC filed a corrected application to replace the previously filed version. On March 16, 2023, the Commission issued an order scheduling hearing, requiring filing of testimony, establishing discovery guidelines, and requiring public notice. The order scheduled DEC's fuel charge adjustment hearing for today, Tuesday, May 30th, 2023, beginning at 2:00 p.m. The following parties have petitioned to and have been allowed to intervene in this proceeding: Carolina Utility Customers Association, Inc., that I'll call CUCA going forward, Southern Alliance for Clean Energy, that I'll refer to as SACE going forward, Carolina Industrial Group for Fair Utility Rates, that I'll refer to as SIGFR3 going forward. On May 4th, 2023, DEC filed the supplemental testimony and exhibits of Signori Clark. On May 5, 2023, DEC filed the supplemental testimony of John Swez. On May 9th of 2023, the public staff filed the joint testimony of witnesses Daryl Brown, Public Utility Regulatory Analyst, Accounting Division, and Feng Zhang, Public Utility Regulatory Manager, Accounting Division, and the confidential testimony and exhibits of Evan D. Lawrence, Engineer with the Energy Division. Also on May 9th of 2023, SIGFR3 filed the direct testimony and exhibits of Brian C. Collins. On May 8th of 2023, DEC filed the rebuttal testimony of Jeffrey Flanagan, some of which is confidential, and the testimony of John Swez, as well as the joint rebuttal testimony of witness Clark and Chris Bauer. On May 9th of 2023, DEC filed the corrected exhibits and work papers for the rebuttal testimony of witness Clark. On May 23rd of 2023, SIGFR3 filed a motion to excuse its witnesses, Brian C. Collins, filed a motion to excuse its witness, Brian C. Collins, from attending the expert witness hearing. On May 24 of 2023, DEC filed a motion to excuse its witnesses, David Johnson, Kevin Houston, and Stephen D. Capps, from attending the expert witness hearing. On May 25th of 2023, the DEC filed the required affidavits of publication. On May 26th of 2023, the Commission issued an order excusing witnesses and accepting testimony. In that order, the Commission excused SIGFR witness Collins and DEC witnesses Johnson, Houston, and Capps from attending the expert witness hearing, and also to receive the testimony and exhibits of these witnesses into evidence and to be made part of the record in this proceeding. On May 26 of 2023, the DEC filed the revised rebuttal testimony of John Swez, some of which is confidential, and the revised rebuttal testimony of Jeffrey Flanagan, some of which is confidential. Also, on May 26 of 2023, DEC filed the joint revised rebuttal testimony and second revised exhibits of witness Clark and Chris Bauer. I now call for appearances of counsel, beginning with DEC.
Good afternoon, Robert Taylor appearing on behalf of Duke Energy Carolinas.
Thank you.
Good afternoon, LaDon Toon, also appearing on behalf of the applicant, Duke Energy Carolinas. Thank you.
Good afternoon.
Good afternoon, Christina Kress appearing on behalf of SIG 3.
Good afternoon, Marcus Trathon for Carolina Utility Customers Association.
Good afternoon, Menashe Magruder from Southern Environmental Law Center, appearing on behalf of SACE. Appearing with me is co-counsel Thomas Gooding.
Good afternoon. I am Will Freeman, and beside me is Zeke Creech of the public staff on behalf of the using and consuming public.
Good afternoon to all counsel. And I'll now ask the public staff whether there are any public witnesses who wish to be heard regarding this matter this afternoon.
Commissioner, we have identified one witness who is with us now.
Okay. Good afternoon. Good afternoon. Okay, please place your left hand on the Bible and raise your right hand. And do you solemnly swear that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Can you begin by stating your name and address for the record?
Yes. I am Beth McKee Huger, and I live at 6017 Bush Road in Brown Summit, North Carolina, 27214.
You may proceed.
Thank you, Reverend. If you could please tell the commission and everyone in this room the reason for your visit and your thoughts.
Yes. Have been all my life an advocate for people with lower incomes, and the additional fuel cost is going to be a substantial burden on people trying to pay their utility bills. I am also a solar producer. My family has a small solar installation and a contract with Duke Energy to sell that power. I'm really concerned about paying extra for the fuel cost for fossil fuels, where you have to pay for the fuel and for the transportation when you can get free fuel from the sky for solar and for wind. Obviously, because we've got our own experience with it, you pay the capital for the solar installation, pay for the maintenance. We pay for the interconnection cost with Duke Energy every month. But the fuel itself is free. And not only is the fuel free, but it is clean, and the heat trapping gases from burning fossil fuels are contributing to climate change, and the methane from natural gas, both in fracking it out of the ground and transporting it and things like that, are a very powerful heat trapping gas that are significantly increasing the temperature of the earth. We see the damage from the severe storms in our country, but the weather severity around the world is even greater, especially in the tropics where drought and floods from climate change. I know that's a little bit far from the fuel cost, but the point is, as the cost of all of that damage to the world is not even factored in, I'm sure, as you're figuring out the fuel cost. but there's no point in paying for fuel when you can get it free. Now, I realize, especially from this previous hearing, that it's complicated contracting for solar production. Well, I know that from our own experience 10 years ago, but I urge you to not have such a big fuel cost adjustment so that people don't have to pay quite as much, and that Duke Energy vigorously pursue the transition to renewables rather than having so many delays. Thank you.
Thank you, Reverend.
Are there any questions from the parties for this witness?
No questions from them.
No questions from the public staff.
Thank you.
Are there any, one moment, please. Are there any questions from the
I'm sorry?
commissioners? One moment, please. Are there any questions from the commissioners? Okay. Seeing none, you may be excused, and thank you for your testimony.
Thank you.
Are there any, for the public staff, are there any additional public witnesses present this afternoon?
We are unaware of any, Commissioner.
Okay. Since there are no additional public witnesses, I will close the public witness portion of the hearing at this time. And are there any preliminary matters that need to be addressed prior to the beginning of the hearing?
Yes, Commissioner. The public staff filed a motion to compel on Friday as part of a settlement that has been reached with the company. We would like to withdraw that, please.
Okay. I assume you're making a motion.
I apologize. A motion to withdraw the public staff's motion to compel.
Okay. Your motion is allowed.
Thank you.
Okay. Are there any additional matters that need to be addressed?
Yes, Commissioner Kimmerer, if I may, again, LaDon Toon on behalf of the applicant. If I may speak to the fact that the company and public staff reached alignment on a partial settlement. And if it be to your pleasure, I can give you some of the core terms of that settlement. We have made the other parties council aware and will work towards formalizing the settlement agreement to submit it for review. But if it works for you, Commissioner Kimmerer, I can give you some of the core
Yes, please.
terms. And of course, public staff, please add context or correct as the case may be. So the company and public staff have come to an agreement on a 16-month mitigant. And so recovery would take place over 16 months. As a part of that, there would be a 4% interest, and that interest would be on the delta between what we would recover through the statutory 12-month period versus what we will cover over the 6-month periods. So the 16-month mitigant. And then in terms of the prospective rate, we are going to use an updated forecast, the spring forecast. Originally, the company used the January forecast and then updated it and then withdrew it. And as a part of the partial settlement and with public staff, we will update, use the most recent forecast and set the prospective rate based off of that. So those are the core components of the partial settlement agreement, and the parties will, and I apologize, am I missing anything?
I was just going to add to that a teeny bit, but I didn't want to cut you off.
Please.
We have estimated that the dollar value of the interest, the incremental interest, is $6.656 million approximately. And that the impact, it'll be an equal percentage impact on each of the customer classes of 13.3, was it 37%? After that, after the under recovery and prospective amounts are included.
And the company will make sure that work papers to support those numbers are reviewed by public staff and submitted along with the partial settlement agreement.
Okay. And this is a partial settlement between DEC and the public staff only. Is that correct?
That is correct.
Okay. And when do DEC and the public staff anticipate preparing the partial settlement agreement and filing it in the docket?
Soon.
Okay. I think we can file it by tomorrow, end of day. And maybe Thursday end of day, if that's possible, Commissioner Kim, right?
Okay. Okay, so by Wednesday end of day or Thursday end of the day? Is that correct? Okay.
I think that's correct. Thank you.
Okay. Thank you. Are there any additional preliminary matters?
Yes, Presiding Commissioner Kim Wright, Christina Kress for SIGFR 3. SIGFR 3, as I shared with counsel for the company, has not been able to consider the terms of the stipulation between the company and the public staff. And in fact, as I understand it, some of those terms continued to evolve throughout the day, and we are still wrapping our hands around what is contained within that stipulation. So at this juncture, I have not had an opportunity to brief my clients on the terms of this stipulation or to get directive from them on how to proceed at this hearing. And so for those reasons, SIGFR 3 would request that this hearing be in recess for enough time so as to allow both the stipulation to actually be filed and for my client to have an opportunity to meaningfully consider it, and also for some potential other conversations with other parties to occur.
And we'll provide a response from DEC, please.
Yes, respectfully, we would like to object and offer as an option, we could put, to provide counsel with maybe a summary, some numbers and exhibits that you can able to review, and instead of calling this evidentiary hearing to recess, we do have witnesses are here who have traveled, and I think that would just be a challenge in terms of their schedule. And so we would be able to maybe do something tonight or even early in the morning. We should have some actual numbers you can review as the impact of your clients you could share with your clients. If that would be an option that Ms. Kraston.
Okay, Mr. Kaler, did you have something you wanted to say as well? Okay. And does the public staff wish to respond?
The public staff is ready to proceed, but we don't have a strong opinion one way or the other, so we defer to the commission's wisdom.
If I could speak briefly, Presiding
Mr.
Commissioner
Trathan.
Marcus Trathan for CUCA. We find ourselves in a similar position with SIGFR. As I'm looking, we're prepared to proceed certainly, but as I'm looking at my cross-examination, I think this settlement potentially impacts what I might ask and what I might want to develop in terms of the record. Would certainly aid in I'm appreciative and sensitive to the fact that we have witnesses here, but just in general, in terms of an efficient proceeding, it would be helpful to have some time to evaluate the settlement that is on the table.
Is there anyone else who wishes to be heard on this motion?
If I may, presiding officer, Menashe Magruder on behalf of SACE would sort of reiterate the same objections lodged by counsel for SIGFR 3 and also counsel for CUCA. Obviously appreciative of DEC's willingness to provide some written work product that sort of lays out at a higher level kind of what the parties have agreed to. I think given sort of the timeline, I don't know if it would necessarily address sort of our core issues with respect to not feeling prepared to really kind of cross-examine or otherwise sort of develop the record in line with sort of what issues our sort of clients see as being live in the proceeding. And so I think similarly appreciative of what DEC has offered, but I don't know if it really addresses some of our core issues with respect to not really being prepared. Obviously, understanding of the fact that this is an evolving settlement agreement, and obviously appreciative of the fact that, there might be some things that need to be papered out, but would also request that the commission be willing to I guess, continue or hold the hearing and recess until parties have had the opportunity to actually see and review a papered or written either summary or settlement agreement so that we can sort of prepare ourselves and also kind of advise our clients accordingly.
Okay, anyone else who wishes to be heard? Okay, so what we are going to do is we are going to hold this hearing and recess until 1 o'clock tomorrow. And during that time period, I would ask that Duke and the public staff provide as much information as possible, hopefully this evening, to all of the parties so that they can talk to their clients, review the information, and then be in a position to have whatever position from their clients. And we will resume again at 1 o'clock tomorrow.
Okay.
Thank you.
Okay. And so the hearing is now in recess until 1 o'clock tomorrow. Thank you.
Thank you.
We'll go on.